I'm Meiselas from the MeidasTouch network. Walt Nauta, Donald Trump's co-defendant in the case brought by special counsel Jack Smith for willful retention of national defense information, obstruction of justice, and other counts. Walt Nauta has just filed a motion to continue or delay the hearing that is set this week for what's called a CIPA status conference on July 14th. CIPA is the Classified Information Procedures Act. And what we've been saying here on the MeidasTouch network is Walt Nauta's stunt of saying he has been unable to find a lawyer licensed to practice law in Florida, thus continuing his arraignment date from when it was originally scheduled on June 13th, continuing it again on June 27th, then finally getting arraigned on July 6th. We said that was a stunt to try to delay the proceedings and try to kick a trial date in this matter against Donald Trump and Walt Nauta as far in the future as possible. That seems to be exactly what is going down here. We reported on the MeidasTouch network that last week on July 6th, after multiple continuances, Walt Nauta said that he finally retained a lawyer, Sasha Dayden. Walt Nauta was finally arraigned after, again, multiple delays, multiple continuances. And now what Walt Nauta is saying is, because I just hired that lawyer, Sasha Dayden, she hasn't had the time to file the necessary paperwork under the Classified Information Procedures Act to make sure that she has all of the clearances to review documents in a classified document case like this one, also cited in this motion by Walt Nauta. My other lawyer, Stanley Woodward, my out-of-state lawyer, well, he's set to begin a trial on July 10th, so he's not available. So what is the Department of Justice doing? The Department of Justice is opposing this. The court made very clear, Judge Eileen Cannon, in a prior minute order, that the parties needed to have all of their paperwork done and completed by before this July 14th meeting, and they had to initiate it immediately. But here we see the strategy developing. Donald Trump using his co-defendant, Walt Nauta, not just as a pawn who Donald Trump is going to throw under the bus, but affirmatively also as a pawn in trying to get delays in the trial date. So we will see what Judge Eileen Cannon rules, if she's going to keep the date of the CIPA status conference. And what the parties are supposed to discuss there is the handling of classified information, the appointment of a classified information security officer who kind of acts like an independent monitor to assist the parties in dealing with the classified information and dealing with disputes over classified information. Here's the motion that was just filed, just hit the docket by Walt Nauta. Motion to continue pretrial CIPA conference. It says, comes now defendant Walt Nauta by and through the undersigned counsel, Stanley Woodward, and hereby respectfully requests the court continue the pretrial CIPA conference scheduled for July 14, 2023 to a date that is mutually agreeable to all necessary counsel of records. Counsel for Trump does not oppose this, obviously. Trump wants to delay. Defense counsel has conferred with the government counsel, and here's where it says it. The government, the Department of Justice, opposed this request and further declined to provide dates when necessary. Government counsel would be available for a continued hearing. The government's like, no, this is the date that was set for a very long time. Sorry, Walt Nauta, if you waited to the end to get, hire a lawyer. We need to move this case forward. So the government is opposing this request, and I'm sure we'll see shortly after I record this video, probably an opposition filed by the government. It goes on to say, defendant Walt Nauta was indicted on June 8, 2023 in this district, despite the fact that the investigation leading to his indictment had long been conducted by a grand jury impaneled in the District of Columbia. It's like, okay, So what? At all times relevant to this investigation, Defendant Nauta has been represented by an attorney licensed to practice law in the District of Columbia. Okay, you committed crimes in Florida. With little notice to Defendant Nauta, the operative indictment in this matter was returned in this district, and only recently, on Wednesday, July 5th, 2023, did Defendant Nauta retain local counsel. I mean, sorry what it was supposed to be like, hey, we just wanted to tell you that we're going to be criminally indicting you. Is there anything else we can do for you, sir? Can we call a car for you? I mean, what are you talking about? You are accused of serious crimes. You're accused of violating the Espionage Act and obstruction of justice.
And now let's take a quick break to talk about our next partner, Fume. Cold turkey, it may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume, and they look at the problem in a different way. Now, not everything in a bad habit is wrong. So instead of drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I used Fume, I was shocked at how flavorful and fresh it tasted. Now, it's easy to hold and perfectly balanced and quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code Meidas to save 10% off when you get the Journey Pack today. That's tryfum.com and use code Meidas to save an additional 10% off your order today.
On Friday, June 23, 2023, the government filed a motion requesting that the court set a CIPA hearing under the Classified Information Procedures Act. Although the government counsel asked whether Mr. Nauta's longtime counsel opposed such a hearing, we did, and provide an electronic courtesy copy of the same. The government did not request any dates when defense counsel would be unavailable for such a conference. On June 26, 2023, this court entered an order granting the government's motion setting a pretrial CIPA conference under Section 2 of the Act for July 14, 2023 at 10 a.m. At that time, Mr. Nauta, through counsel, was not receiving electronic notices. Notice, excuse. Now, notices. You should have told me earlier. I was surprised that I was indicted in Florida. You get what's going on here now. So he claims, okay, he was not receiving electronic notices through the court's filing system. The government did not advise counsel that the pretrial CIPA conference has been scheduled, and even when counsel did learn of the conference, Mr. Nauta had no ability to formally move the court for relief based upon his counsel's unavailability. What are you talking about? We knew about it. So if we knew about it here on the MeidasTouch Network, clearly you knew about it. Rather, it was not until Wednesday, July 5th, 2023, that Mr. Nauta retained local counsel Sasha Dayton, and on Thursday, July 6, 2023, that Chief Magistrate Judge Torres entered an order permitting Mr. Nauta, through his counsel, to electronically file with the court. Mr. Nauta respectfully requests, by the way, you had a very competent, granted out-of-state lawyer who could have told you how you make an ECF filing with the court. It's very, 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 any of us can make an ECF filing. You create an ECF account, you click your case, and you make filings. It's very easy. So it goes on to say, Mr. Nauta respectfully requests the court continue the July 4th, 2023 CIPA conference to a date that is mutually convenient with the parties. As the government has long been aware, Mr. Nauta's longtime counsel, Mr. Woodward, is scheduled to begin a bench trial in the United States District District Court, District of Columbia, on July 10th, 2023. Accordingly, Mr. Woodward will be unable to attend the pretrial conference on July 14th, 2023 with this court. Presumably, the government will argue Mr. Woodward's appearance is unnecessary. And then it goes on to say, and defense counsel is aware of the court's admonition that local counsel must be ready to adequately represent Mr. Nauta at any time. However, as the government notes in its application for the hearing, a pretrial CIPA conference permits the court to consider matters related to classified information that may arise in connection with the prosecution, yet defense counsel cannot meaningfully opine on discovery and motion schedule relating to any classified information before the provisional security clearances, let alone complete clearances, have been approved, nor is it feasible to expect Mr. Nauta's local counsel to appear at a pretrial CIPA conference and to agree upon a discovery and motion schedule relating to any classified information barely a week after she has been retained by Mr. Nauta. Accordingly, continuing the pretrial CIPA conference will not prejudice either the court, the government, or the public interest, but rather will conserve time, expense, and judicial resources while the parties secure security clearances. Conclusion. For the foregoing reasons, Mr. Nauta respectfully requests this court continue the pretrial CIPA conference to a date that is amenable to all necessary counsel of record. So you see they're using the Sixth Amendment and saying, look, I have the right to competent counsel. I have the right to hear witnesses before me. You will be violating my Sixth Amendment rights. And what they're saying is, Judge, you do this, you could potentially be reversed. And so you see how, again, they go to try to use and frankly manipulate the Constitution to basically say, well, we were incompetent, we didn't hire a lawyer, but now you're going to prejudice us. Even though we attack the Constitution, now you're going to prejudice us if we don't have the ability to continue this hearing because no one is going to be ready. I'm interested to see what the Department of Justice response is. We'll cover that as soon as that takes place. And as soon as Judge Eileen Cannon issues an order, we will let you know what Judge Cannon does with this motion. Also, today on July 10th, we should expect the motions to be filed by Trump's team and Walt Nauta's team about a trial date. That should be coming soon as well, when they want the trial date to be. Special Counsel Jack Smith said December 12th of 2023, wants to keep it in 2023. I expect Trump and Nauta to say 2025 or set a status conference 60 to 90 days out after the election in 2024. And then we'll see what Judge Cannon does. That's going to be the big motion right there as well. But we see the tactics already starting to shape up where Trump's going to use Nauta to engage in these types of antics. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers. Thanks to your support. Check us out at Patreon, wherever you get audio podcasts. Subscribe to the MeidasTouch podcast. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.